Welcome to another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences. Dr. Bill Kanasky, two very special guests today, Johan Flynn and Kevin Greene. Johan owns his own firm, I believe, the J. Flynn law firm in the Denver area, and Kevin Greene of Wilcox Savage in Virginia. Gentlemen, thank you so much for joining me today.
Thanks for having us.
Great to be with you.
Yeah, this is going to be a fun episode. I want to hear a little bit about both of your firms, but kind of the way we hooked up is, I look at I get a lot of messages, a lot of DMs and LinkedIn, and I look down and I was like, wow, this is somebody I don't know, and they're telling me about this big case they're in, and it turned out to be kind of a marathon trial. So we're going to talk about your trial. Massive verdict in your favor, so I can't wait to hear about that. But before that, Kevin, tell us a little bit about Wilcox Savage and the type of cases that you handle.
I'm sure it's great to be with you. I feel like a longtime listener, first-time caller today.
There you go. Perfect.
But yeah, I'm at Wilcox Savage. We're based in Norfolk, Virginia, and have an office up in the Northern Virginia area. We're about 65 lawyers. My department is the sort of toxic tort defense department. We have a sort of a niche specialty in asbestos and cosmetic talc litigation. We have our senior partner, Bruce Bishop, has been doing this work for about 45 years. And a few of us had the privilege of coming up under his tutelage and have helped nationally a couple of clients, particularly with respect to experts and with trial work. I've been doing it about 23 years at this point.
Wow. And are you from Virginia originally? Are you a Virginia guy?
I am. I'm from the 757. I'm Allen Iverson territory.
Wow. AI.
Yeah.
You see, when people said AI means something different to our generation. Now, are you a UVA guy? I mean,
I went to George Mason undergrad, which about 4 years after I graduated, they went to the Final Four, and all of a sudden everybody knew what George Mason was.
And they defeated my Tar Heels that season. That was 2006. I do not take losses well, if you haven't figured that out. Okay, enough of you, Kevin.
Yeah.
My God, this is not starting off well. Johan, let's go to somebody with some more composure here. Johan, tell us about your law firm outside the Denver area and the types of cases that you guys handle.
Yeah, primarily I handle asbestos cases. My whole career has kind of been in that niche area for almost 25 years now. I was at a big law firm here in Denver with over 120 lawyers, and in March, at the kind of urging of my biggest client, said, hey, you know what, you might want to just go out on your own, and ran the numbers, crunched the numbers. And as of March 1st, I started the J. Flynn law firm. And then a month or two into the new law firm, I ended up in a 9-week trial. So it was a pretty good start for the new law firm right off the get-go.
Well, there you go. Well, congratulations on opening up shop. Just out of curiosity, just in case anybody else is thinking this, everybody texts me. Like they don't, obviously you're not going to go on LinkedIn going, yeah, I think I'm going to go out on my own. That's something you keep kind of close to the vest. What are some of the benefits and kind of challenges that you've learned here from having your own firm versus being part of a larger firm?
There's a lot of, one of the main positives is a lot of the financial flexibility that the small firm operation gives me. There's a lot more flexibility there than dealing with big firm compensation decisions and things like that.
Headache. You mean headaches?
Exactly. But being, the only partner in my firm, it's just nice being the person who makes the decisions, and the buck stops with you. And
yeah,
I feel like I've had 25 years to get ready for this, and now it's kind of exactly where I kind of wanted to be. And then one of the hardest things is just not having as much support staff, not having the people behind the scenes, the IT department and things like that you kind of take for granted. So but overall, I mean, it really suits my personality, and it suits where I'm going, and it suits my practice to kind of be out on my own now.
Well, good. Well, it sounds like you're both thriving, and that's excellent. So want to hear about your case. If you give us a little background on the case, and then, I mean, a 9-week trial is I mean, we had one last year that went 14 weeks in New York City. I mean, that's a marathon, but I think like anything over 30 days at this point is a grind that just probably physically and mentally just destroys you on a number of levels. But if one of you can give us kind of just a little backdrop on the case, kind of basic case facts, and maybe even kind of why this went to trial as opposed to settle like so many other cases do.
I'll shoot with the background on the case. This was, as you might expect, given our backgrounds, an asbestos case. The plaintiff developed lung cancer back in December of 2018. And in his history was exposure to asbestos-containing brakes. And a case went to trial against 3 defendants. One was a truck manufacturer, one was a manufacturer of friction materials, and one was a manufacturer of clutches. The plaintiff was a truck driver for his career, so he spent a couple of decades as a truck driver, and the allegations related to our defendant was, the allegation was that he was present when mechanics were working on the brakes of the trucks. He had some other exposures from working with his dad, doing some normal automotive car repair as well. He was also reported to be a non-smoker, which is a little bit of a wrinkle in a lung cancer case.
Yeah.
Even in asbestos cases, you often see smoking in lung cancer cases, and that's usually a scientifically reliable cause of the disease. Our plaintiff was a reported non-smoker, but it turns out that he grew up with his dad, who was a pack-a-day smoker. And then when he started working for a couple of years, he was working right next to other mechanics that were smokers. And then when he was a truck driver for 5 or 6 or 7 years, depending on the evidence you believe, his partner driver, they traded shifts, his partner driver smoked in the cab with him. And so there was that smoking history, but that terminated some 30 years ago. So he had a smoking cessation issue to deal with from the scientific perspective as well.
Yeah,
so those allegations.
Yeah, and usually the truck driver is the defendant on the cases I work on. So that's the plaintiff. So that's a little unique wrinkle as well. It does. You know, look how far we've come in this society with smoking. My mom finally told me, yeah, I smoked when I was pregnant. And I was like, oh, great. That explains a lot. That explains a lot. And I remember when I was little, they were smoking on airplanes. They're smoking on airplanes. I told my kids that. They're like, get out of here. I'm like, no, there was a smoking section in the airplane. And they're like, no way. I'm like, yeah. So, yeah, very interesting. Johan, so as you, and so I guess 3 defendants, you said, right, Kevin? Okay, so that pretty much explains the 9 weeks, right? Because you got a lot going on. A lot of parties have to put on this. Johan, what were the jury selection parameters given to you by the bench, and how did you approach it? Because that's really the reason why you reached out to me, is that you had listened to my 4-part Disruptive Voir series. Go ahead and tell us about that.
Yeah, that was really how it all started. It's how I found your posts on LinkedIn. And it was about the Disruptive Voir series, part 1. And it was like a week and a half before we were about to start trial. Wow. And I said, hey, Kevin, I listened to this and I took notes, and I sent Kevin all my notes from the podcast. I said, dude, this is fantastic. This whole theory, this concept of disruptive voir dire was really foreign to us, but it really resonated and made sense to us with what we wanted to accomplish. And I think it also deals with kind of the uniqueness of asbestos cases. It's not really like a cigarette case, but people have strong opinions when it comes to asbestos. Yeah. And so much of what you were talking about in the disruptive voir dire of identifying jurors, bad jurors, good jurors, planting seeds, all the different techniques that you talked about in your series really just resonated with us. And it was huge. And
I mean, that series took, I mean, it was a 4-part series for a reason. I mean, I give a speech on this, it lasts all day almost. It's so complex. But based on what you listened to from the pod, which I pretty much did on the podcast, is I just kind of gave the speech to the podcast and broke it up into 4 parts. And I think I know the answer to this, but was it reasonably easy to take what I was talking about and implement it?
Oh, I think so. Absolutely. I mean, there were certain things that we picked that we thought would work best for our case and wouldn't really work for an asbestos, wouldn't work for other cases that would work for ours. But we were really fortunate that we had a judge in Van Nuys, California, that really gave us the freedom to do voir dire. A lot of times Kevin and I have had cases in federal court where our jury is picked in an hour and a half.
Yeah.
But here, jury selection lasted over a week. We went through over 150 jurors. We had 4 separate panels. The judge did the voir dire just on the 12 in the box. So we weren't voir diring the whole audience. All we could do was ask questions to the 12. There wasn't even a 6-pack, which there was 12 plus 6, which ended up causing part of the problem why it took so long. But the judge really believed in the California rules that say, hey, I'm not supposed to put arbitrary or capricious time limits on voir dire.
Yeah.
Which ended up that the plaintiffs would go for 15 minutes with the panel, and then the first defendant went 15 minutes, then the second defendant went 15, and the third defendant went 15, and we cycled back to the plaintiff. So there was a lot of time for us to be able to actually talk to the jury and be able to use some of the things that you call disruptive voir dire techniques that we wouldn't be able to use in a federal court case, for instance.
Yeah, federal's pretty tough, but a lot of state courts, you have enough time, and like you said, you pick the questions that apply to your case. There's a couple different categories of questions. Now, the one thing when I developed this whole, invented this whole disruptive voir dire process, the point being is it's really hard to talk about and teach because everybody's just like, well, what are the questions? It's like, well, you have a question, but you can't start there. Like, you've got to work your way up to that question, because if you go right to the question, a lot of jurors shut down or they don't feel like talking at that point. Can you talk about how you asked these questions and didn't just go right to the main question, but got jurors to open up to actually give you information? Because listen, jurors don't like to talk. It's like public speaking, right? Like it's a lot of anxiety, and kind of how you got them to warm up and open up to you.
You know what I think, Bill, was the most important thing that kind of got our jury panel really opening up was that the plaintiffs asked to do a mini opening.
Perfect.
Under California law, they asked for a mini opening. And Kevin did the mini opening, and he can talk about it in more detail, but being able to distill your case, your whole defense case, into 3 minutes.
Yep.
And then be able, through the course of a 9-week trial, to prove every single thing that you said you were going to do in your 3-minute mini opening, and then weave that into your opening, and then weave it into your closing, was critical. And Kevin can talk about that more, but I think, how many times did you do the mini opening, Kevin?
By the time we finished, we had given it 4 times.
Wow.
And it was the equivalent of what you would call the opening shot for your opening statement.
Yeah.
Right. Where you just lay it all out. You got them, you got their attention for that moment. And the great thing about this situation was, once we had jurors in the box and we had a new panel come in, the jurors in the box heard it again. So we were able to give them all of our bottom line points 4 separate times. The fascinating thing was that our plaintiff's mini opening changed a little bit each time.
Oh, gee, I wonder why.
We were then able to use, right, and say, what really is their theory of the case?
Yeah.
And we had, and it goes back to preparation, of course, that we had really decided, here is the case we want to put on. We were able to put it together in, I think it timed out to about 3 minutes, 20 seconds, something like that. And then that translated, as Johan was saying, to the voir dire and the jury selection questions. They understood why we were going to go into certain topics, but we didn't have to introduce ourselves or the case. We could just start talking. You can understand why we might want to talk about damages and rev up to, asking specifically, anybody ever heard of anchoring? And the first 2 or 3 times we were able to get away with that question, and the third
Now
time,
that's a part of that's absolutely a part of the disruptive voir dire, because the whole theory behind it is, listen, if you want to prevent a problem, expose the problem, right? And so explain how that process went, because that's what the way to prevent, right, the anchoring effect. Everybody well, you just counter anchor. Well, that's not enough. You have to tell the jury, like, hey, there's this concept called anchoring, right? Anybody heard of it? Number one. Then maybe you give them an example of everyday life, like, for example, like in a salary negotiation, right? That's kind of my favorite example that a lot of people are familiar with. And did you get a lot of head nodding and people started to figure out what it was?
Oh, absolutely. I think it really resonated, especially, I mean, the whole idea of the counter anchor versus the anchor. Are you going to be a cheapskate? Are you going to not be? How the jury looks at this? And we were actually able to talk about all those concepts in front of the jury. It was absolutely fantastic. And when we talked to the jurors at the end of the trial, they understood this and they kind of got these concepts. And then what was really kind of crazy is most of these cases, all the plaintiffs do in voir dire is say, hey, can you award millions of dollars? Can you award millions of dollars?
Yeah, exactly.
And they didn't do that in voir dire, really. And then they get to closing argument and they ask for over $82 million in damages. And then all of a sudden the light bulb goes off in the juror's head. Oh my gosh, this is why we've been here for 9 weeks.
And it's anchoring.
Yeah, exactly.
So in the closing, you were able to say,
it's the whole point.
Think that was an anchor?
That's the whole point, is you get to closing and you go, now we talked 9 weeks ago. I know it's been a long 9 weeks, but you remember we talked about this, remember? And you tie it all together is the whole point to this. And then everything, here's the key. Here's the psychological warfare. Everything you accomplished in voir dire, you've just reactivated right before deliberations. And the odds of them sticking to what you want is sky high. You don't make that connection. It was 9 weeks. Hell, if it was 9 days ago, it would not have worked. Now, let me ask you just one more thing about voir dire that I want to talk a little bit about the openings. During the voir dire process, did you guys feel and maybe notice some separation, not just between you and plaintiff's counsel, but you and your co-defendants on the effectiveness of what you were doing?
I would say absolutely 100%.
That's awesome.
100%. It was so different. No one really knew what we were doing.
Were you getting some funny looks like, okay, what are these dudes doing?
And even the judge looked at us like, what are these two guys doing? What are these two pro hoc lawyers in California doing in this case?
We're disrupting, Your Honor.
This isn't the way voir dire is done in California. They didn't say that, but it was definitely different, and it really had an impact.
And I think, everybody's worried, like, well, what if they object to these questions? I don't think there's a lot of grounds for objections, especially when you're get like the pre-commitment questions. Right? Like, yeah, everybody says they're going to follow the law, and then it goes out the window once you get into delibs. Well, number one, can I have your public commit? Like, raise your hand and verbally, right? Massive psychological impact. And then the follow-up is, do you promise to keep other jurors in law? Like, if you notice a juror going off the rails, not following the law, being all emotional, do you promise to reel them back in? Like, the psychological impact of that is extra. There's a ton of research behind that. No one asked these questions, and that's why I came up with this stuff. But that's really terrific and awesome. So, in the order of the openings, where did you fall in the batting order, Kevin?
We were first. We had talked with our co-defendants, and we wanted to be first in order to try to frame the case. We were first in our mini openings, and then first in our opening, and so
always helps.
We took advantage of that, and really. I'll say one interesting anecdote. We had prepared slides for the opening, and the plaintiff objected to most, if not almost all of them.
Yeah, of course.
We had some argument about that, and at some point, the judge did make us remove some of them. Okay. And we absolutely agree that was to our benefit. We probably overslided to start. And the judge taking us some slides away from us probably made us refine the argument even better and probably made it more engaging. So
that probably worked in your benefit. I did a podcast this morning, very early. I was up at 3:30 thinking about the podcast. I got to get up, or I got to start talking. And it was about the whole, like, less is more. That's scientifically proven. The problem is no one's capable of this because it makes you feel like shit. So you're like, wait, I'm going to get up there for 20 minutes as opposed to 45 minutes or an hour and then sit down. It's almost like that. God, that's not enough. But from a juror perspective, it's actually really enough. So that's interesting. Johan, did you give the opening?
No, Kevin did.
Okay.
I mean, Kevin was generous in saying the judge took out a few slides. The judge took out over half of the opening slides. So,
which, by the way, when I critique opening statements, I pretty much eliminate half of it and go, now you're perfect. And the defense counsel is like, what? I go, I eliminate half, and you're going to be right where you're. I tell witnesses this when they give explain answers. I go, whatever you think is appropriate, cut it in half. Boom, that's your sweet spot. No one gets this. It absolutely works. So I'm glad that turned out to be a benefit. How did you get
on the opening? Just on the opening, we did get some comments from the jurors afterwards, and the key is to be interesting but not distracting with the slide, right? And to make sure that the slides have an actual takeaway. I think what's one thing we're pretty good at, I think, is before we put a slide in front of a jury, it's like, what is the message from this? Why are we putting it up there? And having fewer slides means you have more of those moments when maybe they look up and get a takeaway, and it's not just click, click, click through the slideshow.
Cognitive saturation. And I tell you, jurors get overwhelmed by too many slides and too much stuff on your slides. And again, if you don't understand the science behind this, you can go out there and do your best and you totally overwhelm and lose the jury. You don't want to do that. What was the relationship like between you and your co-defendants? I always find this fascinating because I work on cases where everybody's on the same team. I work on cases where no one's on the same team. How did that work out?
We had a group that we mostly knew. This is a pattern litigation, and so we had not tried cases with our co-defense counsel before, but certainly knew of them in the space. We had similar factual defenses. Our legal defenses were not completely aligned always. Our scientific defense was absolutely the same. And so, as you can expect, there were times when we were trying our best to coordinate as much as possible. And then there were times where we just needed to do things on our own, up to and including, crafting the verdict form.
Absolutely. Johan, how did you deal with because this is an issue we have to deal with a lot. How do you get in front of a California, you're in Van Nuys, and like, hey, I'm from Denver. He's from Virginia, you guys are outsiders. Like, how do you bridge that gap when you're the out of town guy? Because I've seen this work beautifully. I've seen it completely backfire. Like, you didn't walk in the court with the UCLA hoodie, right? I mean,
no.
Okay.
The judge was all about UCLA though, and there was a lot of people from USC, so that was always a fun discussion.
Well, they don't get along. It's like Duke Carolina. It's just it's not going to happen.
Exactly. But no, I mean, it's kind of strange that it never actually got brought up that we were really from out of town.
Oh, wow. Okay.
I don't think the jury ever knew really that I was from Denver and Kevin was from Virginia, and never actually, a lot of times the plaintiff lawyers bring that up on purpose.
Sure.
That these out of town guys flew in for this case, and that really didn't play out that much. I mean, I've had prior cases in California a bunch over the years, prior trials. So our knowledge of California law is pretty high in the specifics, and knowing how the court procedures work, we kind of had a really good sense of that going into it. So the fact that we're from out of town really didn't play a big role in the case. And I'm not sure the jury even knew that.
Excellent.
The judge as well. He played this right down the line. We didn't get home cooked by any stretch.
Which really helps because you never know.
Experience. With the judge.
You never know what judges. So every trial has its share of challenges and surprises. And I think, in 23, I've been fortunate enough. I've worked with some really, really good trial attorneys. And one thing I noticed about really good trial attorneys is they can call audibles at the line. They can make adjustments when something happens and you're like, oh shit. Didn't expect that, and you've got to make a move, and you got to work on instincts. What types of maybe challenges or surprises did you deal with in this particular trial?
One issue we had was that neither the plaintiff nor the defendants called all the witnesses that were on the list.
Wow.
There was a long list of experts on both sides, and the plaintiffs several times had indicated to us, Dr. So-and-so is coming on Wednesday, and maybe this doctor's coming on Thursday, and it just never materialized. And so by the time we got to our case, then we were kind of looking back at what did they actually put in to evidence that we need to rebut. And so, especially because it had taken so long, but not only because of that, we ultimately didn't call a couple of our own experts and took credit for that in the closing. There's a reason we were able to expedite our defense, because we responded to everything they put on. And we've proven everything we said we were going to prove. But to me, that was one of the things that was always a moving target, as our judge liked to say about trial.
It's hard to prepare. It's hard to prepare when you don't. Yeah.
We prepared for a couple of witnesses 2 or 3 times that never came.
Wow. Interesting. Johan, any kind of surprises or challenges that you saw, and how did you deal with them?
Yeah, I mean, there were a number of different surprises. There was one evidentiary issue we argued, I think, on like the first day of trial, and then we ended up winning that issue. And then the plaintiffs brought it up 7, 8, 9, 10 more times.
Wow.
They kept re-raising the same issue. And, and then the one day towards, I kept having that one binder on that particular issue in my trial briefcase the whole time. And then the one day I didn't bring it, the judge almost reversed himself. So I was like, you got to be kidding me. But that was one of the more difficult things, is just the constant re-arguing of certain evidentiary issues that we won or we lost. That was really, really difficult for us.
Any surprises with witnesses? Sometimes you get a witness that goes rogue or says something you weren't expecting, or, California, it's like, hey, OJ, try on the glove, right? I mean, was there any type of moments with witnesses where you're like, damn, didn't see that coming?
The one thing that we kind of did in jury selection that we were worried about in these cases where the plaintiff is living is, our kind of fundamental rule is when there's a living plaintiff and they've been deposed, when they show up at trial, their testimony 99.9% of the time, they're going to change their testimony.
Yeah.
So what we did a lot of time in voir dire was talking about the importance of the oath and raising your hand and what it means to tell the truth, the whole truth, and nothing but the truth.
Nice.
And talk about that. So when someone changes their testimony and asks the jurors, well, if someone came and sat in this witness chair and I walk up next to the chair, I almost sat down in it, and raises their hand and say, hey, I'm going to tell the truth. What does it mean if they change their testimony? Because we thought the plaintiff was potentially going to change his testimony in significant ways.
Great seed to plant.
It didn't really materialize that way per se, thankfully. And perhaps it probably didn't. The plaintiff tried to get the plaintiff to change his testimony, but he wouldn't. But that was really one of the things we kind of did preemptively, because it's hard to bring up in closing and say, yeah, well, the plaintiff changed his testimony. What does that mean? You got to kind of lay that seed early in the voir dire, the mini opening, opening, how important it is to tell the truth.
Yeah. So how did you handle the plaintiff on cross-examination? What was your strategy going in? Because there's a couple different ways you can do that. And was it similar to your co-defendants? Were you all kind of the same, or was it different?
Our co-defendant, the truck manufacturer, went first on the plaintiff, and I thought did a really excellent job and identified, the key things in his testimony, locked him down, pinned him down as to what the product identification was, as to whose brakes were used on the truck, etc. And that allowed me to come in on my cross and kind of just hit the major, kind of the theme points, the thematic points that we wanted to hit that supported our defense. And it really, I think, played well to have someone else do kind of the heavy lifting, and then I could kind of come in and just hit the particular small button issues that we wanted to hit for our client. Nice.
Talk a little bit about, go ahead, Kevin.
I was just going to say, going back to your prior question, that was one of the witnesses where there really was strong coordination. We had a group plan on what we needed from the plaintiff, and it was just really well executed across the board.
Yeah, and you got to be careful with the plaintiff, right? You can, right? You could go Lieutenant Caffey, right, on the, and go really hard, or you be more strategic, and jurors pay attention to that stuff. It sounded like you guys had a good balance. So you get through 9 weeks. I remember you guys giving me updates on, in my DMs. I'm like, you're still going? I'm like, oh my gosh. Because I didn't hear from you. I'm like, oh, I wonder what happened. I wonder what the verdict was. Like, no, we're still at trial. So how did you feel at week 8.5? How did you feel physically? How did you feel mentally? Because that's a grind.
I think this is where having a team is really important.
Yep.
We had a great war room. Johan and I have done this together before and have a good chemistry. We had a trial technician from the Rosen LTC group in Charleston who was with us, and a great addition. Person who not a lawyer but seen lots of trials, and so had been through it and provides good input. We had a paralegal from my office, Danuta Epstein, who was there and living it with us. We found a great place to go to dinner every night right across the street. And so we had a good routine to try to stay as healthy as possible during a long trial that way. And kind of that Saturday morning into Saturday afternoon was kind of always an off day. But I think having good people to work around made a huge difference in them.
Yeah, I mean, I would definitely second that. I mean, I think one of the things that we're blessed with is a client that understands, who's tried cases. So it's a client who actually understands how difficult it is to do what we were actually doing. And we've kind of come up with this rule now where we'd like to have 2 trial lawyers try our cases, because having one person do this for 9 weeks, I think would be just virtually impossible. And having someone as excellent as Kevin, as co-counsel and working together, we were certainly tired. We were certainly exhausted towards the end, but we were certainly motivated that the case we wanted to put in, we got to put in. The evidence we wanted to get in, we got in. And the points we wanted to argue, we were going to be able to argue. So we felt very confident, I think, towards the end. But you never know what a jury's going to do, but we certainly felt like we were able to try the case the way we wanted to try the case.
I reached my point almost. It was that moment when I thought we were done, where we had closed, gave it to the jury, they had it. And so I thought, all I have to do tomorrow is show up and just wait. Yeah. And then they had questions and they wanted certain testimony read back. And they weren't simple questions in terms of identifying the testimony. So we spent that last night going back and forth with meeting and conferring with the plaintiff's counsel on what testimony was responsive to the question. And at that point, I thought, we're supposed to be done.
Yeah. Give me a break. Wow. So tell us about the verdict and tell us about particularly your emotional response afterwards.
The jury was out for about a day and a half. It was a jury that had bonded significantly. To me, they were one of the stories of the case, because they were together for so long. Our understanding was they were going to have a potluck together a week or so after the verdict. But so they had bonded, and they were very careful as well. So that's why it took so much time. We had, with the agreement of the plaintiff's counsel, come up with question 1 on the verdict form, which was whether asbestos, generally not related to any particular product or defendant, whether asbestos was a substantial cause of plaintiff's lung cancer. And so our argument was, you answer no to that question and you're done. Yeah. So at the end of the first day, we kind of thought, well, maybe you answered question 1 quickly. So they started asking questions, and we get into day 2 and you start to think, okay, they're spending some time. And then we were actually trying to answer another of their questions when we got the 2 buzzes from the jury room, and they came out. It was fascinating because the foreperson, who was unexpected, stood up, and before he gave the verdict, he thanked everybody in the room. He thanked the plaintiff's lawyers, the defense lawyers, the judge, and the staff. They had really enjoyed the experience, it seems. So then they read the question, they answered to question 1, and the text chain started going crazy.
That's awesome. That's awesome. Johan, how did you feel when you heard that verdict?
It was a big relief. You never
Yeah.
know what a jury's going to do. You have a sense of where you think things are going to go, but you never know
Hmm.
until, they read that verdict. And it was a sense of elation and a sense of relief, that, that the jury really understood what we were talking about. And, this whole case, to me, looking back on it, it was all about the jury selection process and the jury that we picked and where we got to. I mean, both sides didn't use all their strikes. We still had strikes left, and we agreed to the panel. We started agreeing to it, then they started agreeing, and we kind of worked through it. But it's the jury we picked, like Kevin just talked about. I mean, these people were going to lunch. They had a text thread. They were communicating. I mean, they were friendly. They were just a fascinating jury of really intelligent people that were really smart and educated. And it was very different from a lot of the juries that Kevin and I have seen around the country. We were really, Van Nuys is a really good venue to get some really good jurors. And they took their time. They were deliberate, like Kevin said. Those questions were kind of freaking us out. The two days of questions, it was just like dying. I'm like, oh my gosh, this case is going away from us, And then lo and behold, they come back and answer yes to question one, and it was a huge relief.
That's really fantastic. Well, congratulations to both of you. Were you able to talk to any jurors afterwards?
They as I said, they bonded. They wanted to take a picture with the judge in the courtroom after it was over. And then we talked to them for quite a while afterwards. They were very generous with their time and shared some things they liked, some things they didn't like.
Yeah.
But I think one of the takeaways was that they did see us as sort of honest brokers of the evidence. And man, if you've got that type of personal credibility
Absolutely.
you're starting in a good place. That was good feedback. They gave good feedback on the slides. That they enjoyed hearing from the witnesses. They felt like even in our cross-examination that we were not unfair, but we were making our point. And that when we put our witnesses up, we let the jury hear from them. They commented how much they appreciated that, even though I think we were probably more leading than we should be in direct examination, but that's the way you do it.
Exactly, right?
Good.
Awesome. Well, again, guys, thank you so much for coming on. It's great to hear a wonderful story. I know you guys worked very, very hard. I know Johan jumped on an airplane and went to Germany to drink beer for 2 consecutive weeks after this, which is probably after a 9-week trial. Hey, to each his own. Kevin, were you able to get a little downtime?
I did. I will say that July, I spent a little less time in this room than I otherwise would have, for sure.
Well, good.
Yeah, I mean, I would definitely say though that these techniques that you taught in that podcast, those 4 episodes, made a huge impact on both Kevin and I, and really played a huge role in us, and what we did and how we picked this jury. It all started with that, as Kevin said, the honest brokers of the truth, and that all starts in voir dire. When you personalize, you become human to these people, and you talk to them, and you're talking about these complex psychological topics that resonated from that moment till the end of the trial. A verdict came out. It's really amazing.
Well, thank you. I'm trying to change the world. I am, and I put a lot of work into that. And it's called disruptive voir dire, but when you really think about it, you're actually bonding with these jurors more in this process. It's disruptive to your co-defendants and plaintiff's counsel, but it's not disruptive to the jurors. This actually has the opposite effect. And so that's a big deal. Well, again, guys, congratulations. Thank you so much for being on the show. Hang around. We'll chat a little bit. To our audience members, thank you so much for participating in another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences. We will see you next time.